Senator Cotton.
Goodness. Mr. Channon, if you think it's tough being questioned by Senator Warren, try to be on her first-year contract class panel one day. That's even tougher. I'd like to turn my attention to the Credit Repair Organizations Act of 1996, also known as CROA. This is a law that was designed to root out the fraudulent practice of credit repair clinics, promising consumers that they can remove negative but accurate information from consumers' credit histories. The law's strict obligations and penalties enforced through public and private cause of actions have been useful in preventing some forms of fraud peddled by credit clinics. But at the same time, over the past several years, the plaintiff's bar has pushed courts to expand CROA's reach to cover important services never intended by lawmakers to be subject to CROA's requirements and penalties, including credit monitoring and credit education services. One way that companies providing these services have been able to limit their exposure to CROA has been through immigration or arbitration clauses. Mr. Hirschman, I'd like to ask you, does the CFPB's forthcoming arbitration rule expected next year make the need for CROA reform more urgent or less urgent?
Senator, I honestly don't know the answer to your question, but I'm happy to get back to you on that. We're expecting the CFPB to issue an arbitration rule literally within months, and I'm happy to get back to you on that.
Okay. The FTC, which is in charge with enforcing CROA, has been on the record in Senate testimony stating that it's very sympathetic about the need for reform to protect credit monitoring and similar services. Do you see any risk with the intersection of the CFPB's potential arbitration rule and the FTC's position?
I'm happy to get back to you on the question.
Okay. Are there any other unique issues with respect to the application of this potential arbitration rule as it applies to credit bureaus that the CFPB should have in mind as it goes forward with its arbitration rule?
Well, arbitration is certainly a much more cost-effective and timely way for consumers to get redress, and particularly when it's very expensive for individual claims that are not classable to get into the courts. It's unlikely that consumers will want to go to the expense to take those claims into the court, and if they're not classable, even the class action, even with the low percentage of consumer benefits that come from class action, are unlikely to take those as well. So we have to look carefully to make sure that and it's one of the things we've urged the CFPB to do, is to look carefully at what consumers would lose if they take away arbitration.
Thank you. And if you can take those earlier questions for the record and respond, I appreciate very much the analysis that you've submitted to this committee. CROA reform is something on which I will continue to be engaged, particularly as we look forward to new arbitration rulemaking impacting not just Arkansas consumers, but also many Arkansas jobs as well. So I would like to receive your insights in the future on the record if you could get back to us.